Good morning, ladies and gentlemen, and welcome to today's webinar of Wolf Theiss. My name is Peter Oberlechner. I am partner in the real estate team of Wolf Theiss, sitting in Vienna, and I have the honor and the pleasure to have with me as regional experts today my partner Anna Rizova in our Bulgarian office, sitting in Sofia, and Mr. Flaviu Nanu, sitting in our Romanian office as expert on the Romanian real estate market and legal issues. Today's topic is again the repurposing of real estate, changing the use of real estate, optimizing given properties. Why that? Um, you will have noted that, just one step back regarding the technicalities of the webinar. We hope to be done within an hour. You have the possibility to ask questions and make comments basically throughout the webinar in the chat function. And we will be delighted to answer your questions if possible at all. Now, again, to our topic, repurposing of real estate. It is to be seen that the COVID crisis has accelerated some developments that we see on the markets that have been ongoing for quite some time, which is change of demand and change of demand patterns as regards real estate. The COVID crisis is not the sole cause for these changes, but it has certainly worked as an accelerator to these developments. Clearly, there is, for instance, a shift from brick and mortar real estate to retail to online retail. There is an increasing need for residential real estate throughout all larger cities of Europe and worldwide, of course. There is an increasing demand of logistics real estate, and hotels are, especially the urban hotels, are facing problems. There is questions of whether or not there were too many already before the crisis, and there is the question as to how quickly it will be possible for people to travel again and to fill up these hotels again. There is a tendency that we see on the markets to convert some of these hotels into residential. Now, this is the landscape that we are moving on, and we are exploring. Our aim and our purpose of today's webinar is to explore how easy or how difficult it is under the legal systems of Romania and Bulgaria to effect such repurposing of real estate in practice, how the legal process basically works. Now, before we dive into the middle of the legal topics, maybe also as a kind of little warm-up exercise for you, out of interest, we would be keen to learn for which types of property you personally see, if at all, the greatest need to find new, different, or additional uses in future. Multiple answers are possible. You have these questions in your chat function. And we're using the classical categories here: retail, hotel, office, logistics, residential. Now, again, the question, for which property types do you see need to consider alternative uses in future? Give you just a few minutes to provide you with your answers. You can just click at the respective category in the chat function. Thank you, Monica. We already have results. Interestingly, our audience of today sees great or relatively great need in the instance of offices, followed by retail. Now, clearly, as regards offices, I think you're absolutely right. There is an increasing tendency for enterprises to have their staff, if possible at all, working from home. Home office is a big topic. So the question is whether we need all the office space that we have also in future. And for retail, yes, there is this already long story of increasing need for online retail. Now, another question that would be of interest for us to learn would be whether you and your company, in whatever field of business you're active in, um, are presently dealing with a conversion of property with a change of use, issues regarding the properties that you either own or manage or finance. So the question is in how far this is a topic that is, so to say, personally, professionally affecting you at the moment. Also here, yes or no? Right. It seems that some of you are dealing with this, but others are just watching, as it seems, on grounds of possible future involvement or out of professional general interest. Now, maybe to dive into the different regions that we are dealing with today, starting with Bulgaria, with my partner Anna. Anna, as regards Bulgarian law, how easy or how difficult is it to have a property repurposed under Bulgarian law? What's the legal process? What are the legal prerequisites?
Thank you, Peter. Thank you for the introduction. Good morning, everyone. I'm really pleased to be here today to discuss the topic of efficient use of property, efficient use of buildings. And indeed, the first question which arises when we talk about use of property, it is there any limit? Is there any requirement to use property based on certain pre-established, defined conditions? And indeed, when we talk about buildings and we talk about property, the Bulgarian law and the framework give a very, very well-structured approach and definition on how each property is to be used. It starts with the overall zoning plans, which are adopted on the level of entire city, municipality, or several municipalities, depending on the territory. And this zoning provides different zones and how they are to be developed to really address the social needs of the respective territory and to create the needed communication infrastructure between the various zones and access to those zones. And based on these zoning plans are developed further detailed development plans for particular land plots or several land plots or quarters. The detailed development plans really provide the purpose of the buildings, but also the density and of the construction and public access to those buildings and their functional use. Further to the detailed development plan, all the investors develop construction designs, and based on them, there is a construction permit. And once the buildings are completed, use permit is issued finally, which clearly reflects all of the requirements and norms and standards for the buildings which are in place, but also their designated use. This is then reflected in the register of cadastral map, which is a public register which covers the entire territory of the Republic of Bulgaria, and also covers every specific territory, but also building, and the designation and use of the buildings is also included there. So once set, the buildings are expected and required to be used as the purpose which they are developed. And when we talk about this, we then ask the question, yes, but economic conditions change. Can we change this use? And indeed, it is considered by the legislator and by Bulgarian framework that such change of use is actually acceptable and clearly defined. What are the steps and the stakeholders to implement such a change of use? It is defined based on the general legislation, which is the primary legislation of the laws applicable, and also developed further in secondary legislations, which are regulations and more specific requirements. But basically, if we divide the main scenarios of change of such use, we can define the complexity of the process based on the fact whether change of the use of the building would entail certain construction works. If construction works are needed, then definitely the process of change of use would include the issuance of new construction permit. And actually, the issuance of new construction permit is the process which is to be followed when a building or any construction works are to be initiated and started. They have to comply with the requirements of the detailed development plan. In cases where detailed development plan actually requires that the purpose and the function of the territory is such that, for example, it is for residential, but mainly residential buildings, but we want to have administrative buildings more. And if such administrative buildings actually are not provided in this detailed development plan, requirements for change of detailed development plan would trigger, and we would need to go through the procedure of change of development plans. They are exceptions of these requirements and steps. For example, if we go from administrative building into residential and we are in the area of residential zoning. So this is something which is clearly stated in the law, and it is quite transparently developed, not only for land plots as such and their designation, but also when we want to change the use of the buildings. And talking about the framework which is very important is applicable to the entire territory of the Republic of Bulgaria. It is the main legislation is developed in the Spatial Development Act, which shows all of the steps of the planning, design, and building process and approval of building process, where the change of use of buildings is also included. And based on it, there is a second legislation which is related to the standards and norms when the design and planning for construction is developed. Considering some specific areas in Bulgaria, like the capital city or the Black Sea coast, we have as additional layer, we have the Development of Sofia Municipality Act and Black Sea Development Act. They cater for the functionality of these particular territories, and they have not different processes in terms of planning and change of use and construction, but just add some specifics on the functions of the territories. For example, how the beaches are to be used, some protected zones of the sand dunes, or industrial zones in around ports, etc. So this process is quite clear. And another piece of legislation which is relevant also is the Cadastral Map Act with the secondary legislations, which allows for very clear registration and access to everyone to understand what are the properties, what is their regime, and what is their state of use.
So, Anna, if I may just briefly interrupt, because I think this is really kind of a difference to what we see here in Austria. It's a small country, but we have 9 different construction codes. We have 9 different zoning laws. I mean, they don't differ that much, I would say, in fundamental aspects. But I mean, as lawyers always say, and the devil is clearly in the detail. So when I understood you correctly, when you are kind of considering to repurpose real estate somewhere or anywhere in Bulgaria, you can have a helicopter view on the applicable laws and norms provided irrespective of where you sit, and have a fairly good picture of what you can and what you cannot do. Clearly, of course, with all the additional requirements that you outlined for the for sensitive areas such as the Black Sea coast, or clearly for the capital city, where probably the pure density of development necessitates additional requirements. That I think is a fair summary.
Correct. This is a quite good view and summary.
Yeah. So, and when you think of practicalities now of processes, is there, and because this is then treated by local authorities, not by central authorities, to have whatever, to change a construction permit or to change a use permit, are there significant discrepancies in the time that is to be expected for such processes, depending on where you want to do what?
Yeah, it's a good question indeed, and this would very much depend on the few actually relevant questions when we want to do some process of change of use and development. On one side, the general questions on how big is the change of use, how critical is the construction, how what is the current zoning, how the change of use would affect the neighboring plots. This is something which is valid for everywhere. But I would definitely also say that depending on the municipality and the area, we see different terms and different implementation times. And this is not something which depends on the law. I think this is mainly in dealing with the authorities. And definitely in Sofia, you would have many more considerations, many more administrative bodies which are much more intensively subject to workload and considerations that they need to take into view when they do assessment of the plans. Because one plan or a proposal for change of plans can be submitted and can be returned several times by various departments, just in order to make sure that the most efficient approach to the various standards and norms of construction and solutions of the systems is applied. But when you have smaller municipalities, when you have less density, when you have less interested parties, and smaller impact on the environment or the neighboring plots by the change, you would have quicker processes. And I would say that you would have quicker access to the smaller municipalities and expert in those municipalities than in Sofia, which is natural to be expected. And yeah.
Do neighbor rights play a large role in practice? I mean, let's take the example that, I mean, you have, let's say, a hotel that you would want to convert into apartments, or that you want to have mixed use for, you want to put a medical center in, and you want some apartments, and you apply for, most likely there will be structural changes, certain structural changes that will be needed, so you will presumably have to go for a building permit change and use permit change and all of this. Is neighbor rights is this an issue? Can they slow down things?
Yeah, this is a very good question, since most of the time we affect someone else with our activities. Indeed, the law defines that there is a group of interested parties who can intervene into the process, and depending of the level of the plan or the building permit, which is subject to administrative procedure, the circle of interested parties would vary. So on one side, it depends on the administrative procedure, but on the other side, as you mentioned, would also depend on the particular change which is made. And in that respect, the Spatial Development Act, for example, gives an exception when we have building which is for non-residential or administrative office purpose to be changed into residential, and the zone is residential. Actually, the law allows not to obtain the consent of the neighboring owners in the residential area. It is considered that actually this would fit into the entire purpose of the zoning, and no additional discomfort would be impacted to the neighbors. However, if in a residential building, whether some part of it or another building would need in the same area would be changed from residential to administrative office, then you change the intensity of the use of the building, you change the noise if you want, you change the requirements for access, and then there are neighbors which would be affected, and depending on the exact change, neighbors could have part in the process and could object to the proposed changes. So they are a factor. And what we advise our clients is that for each particular case, one of the first steps, along with the other procedures which are to be initiated, to really assess and consider what would be the affected parties, what would be the interested parties as defined under the law for the specific process in that particular case, in order to address their concerns or potential concerns in advance in the plans, have clear communication, and really make sure that delays would be addressed in advance by addressing the questions and concerns of the relevant parties.
Now, interesting. I mean, what can be seen, I think that this is really it's an expert topic. And of course, each project requires individual assessment for checking whether or not it's feasible. And I think there would be many more kind of interesting aspects to be touched upon or covered. But let me just touch upon maybe a last topic that I would be interested to learn more about. You had mentioned local zoning regulations. Of course, they define the framework of what is possible and what is not possible to do. Now let's assume that certain repurposing of a project requires an intervention with these local zoning regulations. You would need a change for local zoning regulations. Random example, you have an old industrial complex that is no longer being used as industrial complex, that is vacant, and you have an interesting project to put in fancy apartments, lofts, whatever, into this old industrial complex. That would most likely be a situation where zoning regulations would not allow for this currently, because it's zoned as an industrial area or whatever it is. As a developer, clearly you would have to first seek for, or an investor or owner for a change of this zoning. Would you be entitled to such zoning? Do you have legal remedies in such process, or are you basically at the goodwill and mercy of authorities when you need such change of zoning?
Yeah, indeed, there are several projects around Sofia which would qualify for such potential development.
Mm-hmm.
And as an investor, the law explicitly provides the legal standing of investors to initiate the process of change of zoning. As I mentioned, the general zoning plans are at the discretion and they are prerogative of the municipal authorities, but private investors can initiate the change of such zoning regulation, the process, initiate the process. And for example, when one of the grounds which is explicitly listed in the law is when the economic conditions for development of the area have changed. Because previously, as you say, the economic conditions really required this zone to be focused on industrial development. This has changed with the time, and actually it is clearly much more efficient and much more purposeful to have it for other purposes. Then the private investor can initiate such process. Such process could be also initiated when some of the plans are either having black holes, put it that way, either by long time lack of complete update of the zoning plans, or we have a situation where they were not that detailed in the particular area, or they were providing for some flexibility into particular a smaller area where detailed development plan is to be developed. So the procedure could be initiated also with the change of detailed development plan. And in order to speed up the process, the law allows that the two procedures, the detailed development plan and the larger zoning plan, are combined into one process. On one side, to have coordination between the two plans, but on the other side, to expedite the process and really to allow for the development of the area. So investors do have standing in this. They don't have full control. The zoning is to be developed in relation to the plans of the larger territory, considering the infrastructure, communication, and also public discussion is included in such development of zoning plans. So this is not something that the developer can finally define, but the developer can initiate the process indeed.
Mm-hmm. Yeah, thank you. Well, very, very final point, Anna, before we leave Bulgaria and enter Romanian territory, spiritually or intellectually, so to say. A model that is, I would say, increasingly used in various countries is contracts between companies. I wouldn't say private individuals, because usually such projects are of a larger scale. Contracts between investors, developers, owners, and public bodies that provide for a change of zoning to allow for a given development or redevelopment or repurposing under certain conditions that the authorities are setting, mostly combined with investments, the need for investments of the private investor, owner, developer into infrastructure. The conditions would be, for instance, to add to the project such and such many apartments for social housing and not only build the luxury apartments, or to add a kindergarten or a school, or to develop a road, whatever. Urban development contracts, as they could be labeled. Germany, for instance, has a federal law to this extent. In our jurisdiction, Austria, our local planning laws allow for in various shades and colors for such contracts. Is this an issue in Bulgaria? Is this a known concept? Is this a route that the country is also going?
Yeah, it is something which, yeah, I've also heard from investors coming from other Western countries like UK, for example. They also have some similar concept as you described. In Bulgaria, we don't have such a clear-cut contract between public authorities and private investors for the development and obligation for development for social housing, schools, or similar projects. What the Bulgarian law addresses is, for example, when there is concession agreement for an infrastructure like an airport. This would also include development of certain infrastructure. This infrastructure could also include some connections to other parts of the area. And we have seen that there were also in the just 2 years ago in the development of Sofia Airport procedure, in the plans there were included some cultural and sport areas to be added so that this area could be developed. So it would be part of the contract between the public authorities and the private investor. Another new concept which has not had yet implementation because the new law came just recently, it is about development of industrial zones. So when the conditions for development of industrial zones are there, there is much more expedited way to develop such infrastructure and the buildings which are within these industrial zones. And they can be office buildings, they can be production buildings, and it's a complex use area. So this is also another way to approach this. Also when there is a situation, when I think of it, situation is where there are private investors which have Class A investment status for development and investment into the country. They also have an expedited way into the procedures also for changing zoning and planning.
Thank you, Anna. I think that was really interesting. Of course, we didn't have time to go through all details, but that I think didn't come unexpectedly. For any follow-up questions that you might have, we have the chat function, and of course you have Anna's contact details, and Anna her team will be gladly available to answer all concrete follow-up questions. Now moving to Romania. Yes, I mean, Romania is a country where kind of much development went on in all these years. There were some hypes, of course, that had been kind of abandoned again. And clearly, it is to be expected, I would say, that in some instances, there is already the need, not only on grounds of COVID, to deal with the repurposing of real estate that had been developed for certain purposes, and the purposes have turned out to be outdated. Now, the question to you is, what does the Romanian legal framework provide in this respect? Is a repurposing of real estate possible? And if so, under which conditions? Is it easy to be achieved? What are the procedural requirements?
Yeah, thank you very much, Peter, for the introduction and your comments. I would say the situation is to a certain extent similar to what we encounter in Bulgaria. So from the level of zoning and uses of various areas in Romanian cities, we have some what we call the planning instruments. So these are divided into, let's say, three categories. One is the so-called general or municipal urbanist plan, which are issued for an entire municipality or city or even commune, and basically sets out the areas with various functionalities and what you can build on each of them. For example, the general split is the following. We have a central area of the cities where the historical buildings are located and where you can build only subject to observance of these rules regarding the preservation of national patrimony. But also in the city center, we also locate what we call the hubs of development, so basically squares or area where the municipality wish to improve or enhance, and where this type of buildings for services, for banking, for insurances, or large companies' offices can be located. Apart from that, there is what is called the mixed use area, which is more flexible or most flexible from an investor perspective, where you can have both residential but also commercial buildings, offices, and all types of multiple functions. These are usually located alongside the main boulevards and arteries. Then there is the so-called living areas, residential areas, which are in part inheritance, let's say, of the communist regime, which used to build huge dormitory, let's say, neighborhoods for workers who used to work in the factories. Where here the main function, of course, is residential, but you can build to a certain extent other function, but not very big, like commercial venues. And then we can mention industrial areas in various part of the city. One perhaps of one of the feature of Bucharest is that it has had in the past a very large industrial area closely to the city center. And this could be, let's say, a prominent example of conversion of area, because now most of these area which located on which factories were located are now converted into various other functionalities. Residential, shopping malls, retail, also office buildings. And this was done, with the understanding of the authorities that industrial function are no longer possible in the city center, and the facilities were moved to the outskirts. So this is the general urbanist plan. According to the law, the municipal authorities are required to update it every 10 years, considering the developments and the envisaged strategies. Below this level of municipal, we have a zonal urbanist plan, which seeks to address particular areas in the cities which are insufficiently, let's say, regulated at the municipal level. And here we have industrial parks, for example. We have city centers, protected areas, which require a more detailed attention from the authorities. And finally, we had the detailed, so-called detailed urbanist plan, which deals with particular plots in case investors want to build the individual constructions. So this would be, I would say, the layer of municipal rules regarding urbanism regulations. After those, there is the layer of building permits. So if the envisaged change of use require the performance of construction works, you would of course need to apply to the municipality for a building permit, whereby the necessary works would be authorized. This is finalized usually through the entering into of a taking over protocol at the completion of the works, and also a certificate which is issued by the municipality confirming that what has been built is compliant with the building permit and the rules and regulations. And afterwards, this change of use is registered, let's say, with the land registry, which is the system of real estate publicity also in Romania. So I would say, from a practical perspective, from the perspective of an investor, there are basically 3 steps that need to be fulfilled. First, checking the zoning and the compliance of the intended use, the new use for the building with the regulations of that area. If the regulations are not sufficient or do not allow the conversion to the extent the investor wants, then a rezoning needs to be performed. Unlike other countries, rezoning in Romania is generally conducted by the investor at its initiative and by its own efforts. So the investor would apply to the local authorities requesting basically a preliminary document, which is called an urbanist certificate, that would set out basically the conditions and the requirements for the rezoning, including some prior approvals and endorsement from various authorities, for example, from the Ministry of Culture, if it's in a historical protected area, from utility providers, from I don't know, the airspace control authority, if you are talking about a high building. There is also a process of consultation with the public in the area. So investors are bound to publish their intent to rezone the area within a newspaper. They need to post a sign at the location of the project. People in the area can gather, can come and present their objections, and it's also the obligation of the investor to address the objections of the people in the area and take into account their, let's say, grievances or whatever problems they raise. And once this is finalized and the technical documentation is submitted, the city hall takes a decision based on that documentation whether the rezoning is allowed or not. What I would say is that, of course, the authorities have let's say, a significant degree of discretion in assessing whether that kind of project and rezoning, let's say, fits into the general area, and if it's compliant with public interest and particularly the interest of the people in that area.
Mm-hmm.
Once this rezoning process, let's say, is completed, then the investor can apply for the building permit, which is, let's say, a second step, require again obtaining new approvals and endorsement from various authorities, preparing the technical documentation, and then submitting again for approval to the city hall. From our experience, what we can say is that if there is a proper rezoning of the area through a zonal urbanist plan performed and approved by the authorities, then it is easier to obtain the building permit, because the parameters for the construction are already there in the zoning urbanism plan. So it's basically a process that has got on tracks, and you can see the end of it. Of course, it's not really a guaranteed process. It's not something, you know, that that can be done in all circumstances. As I said, in a residential area, you cannot build other type of function like commercial or let's say offices, except to a certain extent. In residential area, you are bound to address again the needs of the people. You cannot include activities that would make a lot of noise, that, you know, are pollutant. You cannot build, for example, tall buildings that would take out the sunshine from the residents, from the neighboring, let's say, buildings. But overall, it is a process that that can be considered, and it has been done. Probably not to a very large scale until now, but we do see some pickup of speed in the recent period. So while
So Flaviu, if I kind of it's interesting as it seems, your legal system, the Romanian legal system, allows for, I would say, a substantial degree of, I would say, individual rights and remedies as regards these processes. Of course, there is no success guarantee, as always, when authorities decide at the end of the day, but it seems that as an investor or as a developer or as an owner, you are entitled to kind of rely on certain predefined proceedings, also in such important matters as regards the change of zoning, which I find quite interesting, because we know nothing of this type. As an individual, under, for instance, our system, you can essentially petition for the change of a given zoning, but there is not only do you not have legal standing in these proceedings, or does the individual who kind of petitioned for that not have standing in these proceedings, there is also very little remedies available against decisions on such matters, except when constitutional rights are violated, which is hardly ever the case, one has to say, because constitutional right could be the ownership right that is affected by a decision, but you are at the goodwill and mercy of authorities then, which I think makes the more relevant what I had already asked in the context of Bulgaria, which is the possibility of these contracts, urban planning contracts, because they kind of they are like a ventile basically. Their function is to, I would say, to close a certain gap. And this seems not to be so necessary under Romanian law, or do you have this type of contracts?
No, under Romanian law, this is a very regulated process. So it's really under the law and the regulation. There is no this type of contracts whereby, let's say, the investor would commit towards the authority to build something, or to change the area, or to convert, or to do, let's say, a certain degree of investment. The only potential exception would be in case that the authorities themselves initiate maybe a concession procedure or a type of urban development. It is the case. For example, it was recently here launched this sort of a project by the 5th district of Bucharest. They have a large tract of land, a former military unit there, which was disaffected, and they want to build what they call the city within a city. And they launched a tender inviting investors to submit proposal. They launched some architectural contest over there. The process is still let's say in some incipient phases. But what they want to do is something of a unit there. So there you could discuss of a contract whereby the municipality, let's say, would put forth the land, the rights in the land for a particular period of time, 49 years, and then the investors under a concession or a PPP would come up and build something on that basis, what has been agreed with the municipality.
Yeah.
So this kind of urban development is possible. Also industrial parks, of software parks, IT parks. Some cities in Romania want to build this type of IT parks. So yes, there are some conditionalities, and indeed there is sort of a contract between the municipality and the investors. But otherwise, you know, generally speaking, within the city center or within the limits, if there are no this type of projects initiated by the municipality, you cannot go to the municipality and say, I want to build something, let's sign a contract and I will commit myself to do that.
Yeah.
It's basically the intention, the investor expressed intention, the permitting goes ahead, and finally, if the investor doesn't have money or something happened like it was in crisis in 2008, 2009, some of the projects fall down and they are not completed. So it's not, let's say, a contractual liability towards the municipality, but it's something that has occurred.
Yeah. But I think still concession contracts are a different type of animal, and that would not be kind of the standard route that you would take to have so there a concession contract is just it for basically the main purpose to change a given zoning. Now, given the fact, Flaviu, that there is, as it seems, such an ample, I would say, protection or possibility to exercise individual rights, how is it working in practice? Now, let's assume I have the idea to do something for which I need a change of zoning, and I institute proceedings in this respect. Of course, given also the fact probably that there is always differences throughout the country, how fast or slow authorities are. But let's say, let's take Bucharest as an example.
Yes.
What is the timing that you would say by large would have to be taken into account when there is a project that, let's say, kind of you have this odd shopping mall at the outskirts of Bucharest, and the shopping mall is now empty, unfortunately, and you don't want to tear it down and substitute it with a new shopping mall, but you have the plan to, in part, use it, let's say, as a medical center, private clinic, or whatever. And you want to put in a little hotel, and let's say some apartments. Just using this as a random example for something for which probably a change of the zoning plan would be necessary.
Yes.
How much time would I have to take into account by large as an investor, as a developer, as an owner for such project?
Yeah. Well, I would say that rezoning of the area, if it's indeed necessary, would take around 6, maybe 8 months. You know, with all the permitting and all the consultation procedure, because as I mentioned, you need to involve the public, and there are some advices and endorsement that need to be issued. So that would be for the rezoning, and then we would have another maybe 6 months or 6 to 8 months for the building permit itself, which is a separate process. So roughly, I would say that between, let's say, 12 to 16 months, that project could be completed.
Yeah.
It really depends again on the area. Usually, this type of reconversion are more sensible or more sensitive, let's say, if they are done in the city centers, which are more restrictions. On the other hand, what is, I would say, good for Romania is that there are a lot of mixed-use areas throughout the city, also in the city center, but also in the outskirts. People who usually develop, like in your example, retail or a shopping mall, usually included in the initial building permit some reservations regarding residential potential residential hotels or other area. So considering again all circumstances, I believe this type of projects could be done. What we see, let's say the problems, and from our discussions with the investors, are related to the technical requirements and the costs involved for this type of change. For example, for hotel, you would probably need to change the facade, which is in glass. You need to do something with that to have it approved for residential purposes. Also, the windows need to be open to the outside. There are some sunshine regulations, some fire security also involved, parking places, also bathrooms and sort of wet areas, which involve a lot of costs for changing this type of project. I would say this is less for converting, for example, a shopping mall into an office building. We have an example in the Bucharest city center. One of the shopping malls was called City Mall. It didn't have any success after the initial crisis in 2008, 2009. And then it was bought by an investor and they changed it into offices. Partly offices, part also some apartments in it at the top floor. So it was really a mixed use. And what we heard right now, again, a lot of investors are contemplating, again, changing in particular office buildings into residential. High-profile investors, for example, we read in the newspapers that one of these investors who is developing a huge mixed project with the residential hotel offices and also retail at the basis wants to change one of the towers from office into residential. I'm sure that this is again done at a pretty early stage. I would say that would allow this construction and the cost not to be very burdensome. But this is an option, and we do see this as a trend right now in Romania.
No, that's really interesting, and I think it highlights the significance of the topic. And as you said, Flaviu, I think you're absolutely right. We will see some more things like that in the next years. Not, as I said initially, not only on grounds of COVID and the aftermath, just as a kind of natural kind of evolvement and evolution of markets. And I think this also imposes the requirement, as I would personally believe, on future owners and developers to maybe have their buildings already developed in a way, built in a way that allows for a bit more flexibility in future. Because, I mean, construction prices are rising, there is ecological concerns, it will not become easier to construct in the sought after areas. Of course, there is scarcity of land also. So I think to build flexible pace and in times like these, probably to consider repurposing at an early point of time and not to hold out and to wait and see whether or not, for instance, the offices will be as large as they were prior to home office, etc., etc. I think these are things to be considerations to be made at an early point of time. I just see that we are basically already at the end of our rainbow, time-wise, so to say. I also see that there are no questions in the chat function. Obviously, all unanswered questions have either been asked or will be asked later. I'd like to thank you very much for holding out, for your attention. I hope there was something for you in it. Should you have the urgent need to see all of this again, I think the event is recorded and you can sit down with a can of Coke and popcorn and instead of watching your Netflix series, look at us again, which is certainly very thrilling, as always with lawyers. You see the contact details of Anna and of Flaviu on this last slide, and you also see them at our homepage, of course. And we'd be delighted to hear from you, and we'd be delighted to maybe assist you with any concrete issues, topics that you may have, either now or in future, with considering to repurpose your real estate. Thank you very much for today's attention. Our next event will be next week, the 19th. Same topic. We will be dealing with the Balkans then, and we'll discuss repurposing legal issues regarding Croatia, Slovenia, and Serbia. Thank you again for today's attention. Thank you, Anna. Thank you, Flaviu. And yeah, see you again, possibly next week or at a future occasion. Goodbye and have a good day.